Good morning. We'll call this hearing back to order. I'm going to turn it over to Mr. Butler for a few things.
Thank you, Mr. Chairman. Let's start with one of the last subjects that we talked about yesterday evening. I think there was still a question on the table with regard to Ms. Walker's potential testimony tomorrow, and I believe the remaining question was whether or not SC DN was willing to not have its 4 executives present at the time of her testimony. And I think, Mr. Balsa, you had agreed to consult your colleagues about that question and get back to us. Is that correct?
It is, Mr. Butler, and I am prepared to address that issue as well as a few other issues regarding the events of yesterday.
Okay. Why don't you
regarding
proceed
Ms. Walker.
Yes, sir.
Thank you very much. Mr. Chairman, members of the Commission, given the serious due process concerns that are raised by the restrictions that Ms. Walker has sought to impose on her appearing before the Commission, we thought it was important to take a minute and review the circumstances that have led us to where we are with respect to Ms. Walker. Ms. Walker was originally designated by the ORS as a may-call pre-filed rebuttal witness. Then on October 24th, ORS requested that Ms. Walker, even though she had not pre-filed any testimony, be treated as a pre-filed witness. SC DN objected to that request, and the Commission sustained that objection on October 26th with the Hearing Officer Directive number 2018-156-H. On October 30th, 2 days before the hearing, ORS requested again that both Carlette Walker and Ken Brown be allowed to appear live as pre-filed witnesses. The next day, the Commission, despite the hearing officer's directive entered on October 26th, granted ORS's request to allow Ms. Walker and Mr. Brown to be treated as pre-filed witnesses even though they had not pre-filed any testimony the way all the other witnesses had. But on the first day of the hearing, ORS informed the Commission that Ms. Walker was unavailable for health reasons and would not be attending the proceedings. ORS requested of us, and we agreed, to stipulate that her full unredacted deposition be submitted into the record, and that stipulation is Exhibit 10, and her entire unredacted deposition transcript, including exhibits, are Exhibit 12 in this hearing record. Yesterday, 4 days into the proceeding, we were presented with a letter from Ms. Walker's counsel stating that she has, and I quote, serious emotional issues, close quote, that she is, quote, being treated for those issues, close quote, and will be unable to respond to the subpoena. That letter was entered into this record as Exhibit 54 at 3:23 p.m. yesterday afternoon. Less than an hour later, Mr. Cox announced that Ms. Walker can, in fact, appear, but with conditions. Those conditions include the exclusion from the room of certain witnesses, individuals, and that she will only agree to appear on this Friday afternoon for 3.5 hours. I'll start with the first issue, and that's the issue that Mr. Butler referenced. With respect to Ms. Walker's first condition on appearing before this Commission, we conferred with Mr. Addison, and his immediate reaction was that he wants the Commission to have all the information it thinks necessary to make a decision and is therefore willing to accommodate Ms. Walker's request that he not be present when she testifies. Having said that, let me say this. It is highly improper for a witness whose own lawyer stated has serious emotional issues to dictate the terms upon which her testimony will be received by this Commission. We believe she should be treated like any other witness. Of utmost importance here, she should not be able to dictate any time limits on her testimony. With respect to the time limits Ms. Walker seeks to impose, she is deemed 3.5 hours as sufficient for her testimony. It isn't. And that 3.5 hours, by the way, assumes that the Commission is going to revise its schedule and proceed till 5 p.m. tomorrow instead of 4:30 as is scheduled. She is deemed her time before the Commission to be 1:30 to 5 p.m. on Friday. We think the appropriate thing to do under these circumstances is to treat Ms. Walker as the ORS originally presented her. as a non-pre-filed rebuttal witness whose testimony should be taken at the end of the case along with all the other rebuttal witnesses. She should not be shoehorned into an afternoon with insufficient time for the parties, especially SC&G, to cross-examine Ms. Walker, and perhaps of even more importance, for the commission to have sufficient time to ask whatever questions the commission wants to ask of Ms. Walker. Ms. Walker has leveled serious allegations against SC&G, and ORS relies heavily on those allegations in an effort to strip $493 million of revenue away from the company. Of course, the practical effect of her time limit demand is to limit the company's ability to respond to these allegations through cross-examination. To put it simply, due process demands that we have the ability to thoroughly cross-examine Ms. Walker. The next few weeks are packed with testimony from pre-filed witnesses and dates certain for witnesses who reside outside of the state. 2 dates certain witnesses are scheduled for tomorrow, Ms. Lapson and Mr. Hebert. If Mr. Addison doesn't finish with his cross-examination today, we certainly would think it's only fair to allow him to finish tomorrow morning before those designated witnesses who have flown in from out of town and who we're paying as experts who are here be presented to testify. We now know that Ms. Walker, who resides in this state, is available. The statement that had been made was she was unavailable because of her emotional conditions, but we now know, based on representations made to the commission yesterday, she is in fact available to appear for testimony before this commission. And we respectfully suggest that the commission ought to set a time that is less prejudicial to the parties and the commission and more consistent with the schedule already in place, and that will give the parties and the commission ample time to adequately question Ms. Walker. An afternoon is simply not sufficient. And what we fear is that Ms. Walker means exactly what she says, and that she is going to appear for 3.5 hours and no more. Even if she says she'll come back on Monday or some other time, there's no guarantee that she will. And that raises serious issues of fundamental fairness. If the commission is willing to acquiesce to her demands and conditions, which we believe are highly improper, we would ask that we be permitted to conduct cross-examination first so that we can be sure that we have an opportunity to respond to her allegations. We would prefer, very much prefer, to stay with the current order, but feel that we cannot risk the possibility of her making a speech, followed by hours of friendly cross, and then have her not come back and appear for cross-examination by SC&G and questioning by the commission. Even that process is inappropriate and jeopardizes our right to cross-examine her effectively, and we believe that the far fairer option is for the commission to treat her as a rebuttal witness, as ORS has originally designated her. And if she refuses to appear under the same circumstances and conditions that every other single witness who has appeared before this commission is willing to appear, the commission has her full unredacted deposition available, and we'd be happy to file the video of her deposition so that if you want to watch her testimony, you can. But imagine if we had come to this commission and said, Mr. Winnick, who, by the way, isn't even subject to subpoena, is willing to appear. He's going to grace the commission with his presence, but he is only going to do that for 3.5 hours, and he's going to do that on Friday afternoon. Can you imagine the reaction we would get from our friends and colleagues on the other side? And she should not be treated any differently than any other witness, especially given the serious allegations that she's making and the reliance that ORS is placing on that testimony. So we respectfully request that she be moved to the end of the case with Mr. Byrne, Mr. Duke Scott, and other fact witnesses. Thank you for your consideration of that.
Okay, thank you, Mr. Balser. Does Mr. Cox have any reply that he'd like to make?
Thank you, Mr. Butler. Mr. Chairman, Commissioners, Mr. Butler again, Jim Cox from the White firm in Greenville, appearing on behalf of the ORS. Mr. Balser's statement had a couple of assumptions in there about the conditions of Ms. Walker's appearance that just aren't true. And I think it's important that that in response that I set forth the fact that ORS has been providing information in real time as it's been getting information about Ms. Walker's willingness to appear. That letter that the ORS received from Ms. Walker's attorney That was dated October 31st, the day after Ms. Walker's deposition. It was mailed to my office in Greenville. My office did not receive that until Tuesday. That letter, though, was written the day after Ms. Walker's deposition, in which she indicated on the record, after a full day of testimony, her second day of deposition testimony, both days in which SCENG's counsel, Mr. Balser, was present, in which she indicated that she did not believe that she would be able to testify. And that's what her attorney's letter set forth the following day. And we provided that letter to SCENG. It was yesterday afternoon, near the end of the hearing proceedings, that we learned that Ms. Walker, based on our efforts to indicate to her that the Commission's deep interest in her appearing in person, that she indicated that she could do that, and she gave us a date and time when she is available to do that. We do not know that is a condition, that is the only time period in which she can appear. I think that's the important fact that I wanted to point out, that that's just a window of time that she gave us in which she is available to testify before the Commission, and we are certainly able to follow up with her and her attorney today to discuss what her understanding was in providing that information to us that we forwarded to the Commission, and what her availability is outside of tomorrow afternoon. That was just the initial information that we received near the end of the hearing that we wanted to provide to the Commission. I think it's important to note, too, Mr. Chairman, that the ORS has designated her as a pre-filed witness with our rebuttal testimony a week before the hearing started. The schedule for this proceeding is obviously compressed with respect to the pre-filed testimony, and that rebuttal testimony was sent just a week before the hearing began. And the ORS has designated her as a pre-filed testimony, and then did provide her with a subpoena at her deposition. With respect to general due process issues, SCENG has been present at both of her depositions. SCENG noticed her deposition that occurred on October 30th, and at the outset, the beginning of that deposition, began its examination. So Mr. Balser had ample opportunity to explore in a pre-hearing deposition exactly what topics Ms. Walker is able to testify to. And with respect to ORS's intent at the hearing to present Ms. Walker's testimony, it's the same as with any other pre-filed witness, to allow her to present a summary of her deposition, and then to allow her to be present for cross-examination. ORS does not have any objection to SCENG beginning the cross-examination of Ms. Walker if the Commission determines that would be the most expedient approach to take.
Mr. Chairman, if I may.
And if
Sorry, Jim.
she'll be subject to the Commission's order, and I think the important thing to note as well, Mr. Chairman, and I'll finish here, is that SCENG was willing to allow the pre-filed testimony into the record. Ms. Walker's appearance is obviously SCENG is permitted to cross-examine her, but we understand that the Commission would like to see Ms. Walker and to provide questions to her as well, and Ms. Walker has indicated that she is willing to do that. Thank you.
Okay, thank you, gentlemen, very much for the information. I'd like to hold this matter in abeyance for further consideration. I appreciate your presentations, and from that, Mr. Chairman, I'll turn it back over to you.
Okay. All right. Are we ready to move on? Good? Okay. All right. Everybody knows that we have lots of intervener witnesses that have date certain times. So we're going to begin, we're going to get a little out of order here, but begin with South Carolina Electric and Gas parties.
SCENG would call Mr. Jimmy Addison. Morning, Mr. Addison.
Good morning.
Could you please state your full name for the record?
Full name, Jimmy Evan Addison,
What is your current professional title?
CEO of SC DN SCANA,
When did you become CEO of SCE&G and SCANA?
January 1st of this year,
What was your most recent position prior to being appointed CEO?
CFO,
Or how long did you hold that position?
approximately 11 years.
Did you prepare or cause to be prepared under your direction 52 pages of direct testimony dated August 3rd, 2018, which was pre-filed with the Commission in docket number 2017-370-E?
I did.
Do you have any changes or additions to your pre-filed direct testimony?
I do not.
If I asked you all the questions contained in your pre-filed direct testimony here today, would your answers be the same?
They would.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Jimmy Addison in docket number 2017-370-E be read into the record as if given orally from the stand.
Mr. Addison's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Mr. Addison, have you also submitted 4 exhibits to your direct testimony labeled JAE1 through JAE4?
JEA.
Sorry, JEA.
Yes.
Do you have any changes or additions to those exhibits?
I do not.
Mr. Chairman, also moving to the record is the next composite hearing exhibit, exhibits JEA1 through JEA4 that are attached to Mr. Addison's pre-filed direct testimony in docket number 2017-370-E.
Mr. Addison's exhibits JEA 1 through 4 will be entered as composite exhibit number 58.
Did you also prepare or cause to be prepared under your direct supervision 3 pages of direct testimony dated September 24, 2018, which was pre-filed with the Commission in docket numbers 2017-207E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed direct testimony for these dockets?
No.
If I asked you all the questions contained in your pre-filed direct testimony from these 2 dockets here today, would your answers be the same?
It would.
Mr. Chairman, I move that the pre-filed direct testimony of Jimmy Addison in docket numbers 2017-207E and 2017-305E be read into the record as if given orally from the stand.
Mr. Addison's pre-filed direct testimony from dockets 2017-207E and 2017-305E will be read into the record as if given orally from the stand.
Mr. Addison, did you prepare or cause to be prepared under your direct supervision 3 pages of rebuttal testimony dated October 24, 2018, which was pre-filed with the Commission in docket number 2017-370E?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
I do not.
If I asked you all the questions contained in your pre-filed rebuttal testimony here today, would your answers be the same?
They would.
Mr. Chairman, I move that the pre-filed rebuttal testimony of Jimmy Addison in docket number 2017-370E be read into the record as if given orally from the stand.
Mr. Addison's pre-filed rebuttal testimony in docket 2017-370E will be read into the record as though given orally from the stand.
Did you also prepare or cause to be prepared under your direct supervision 2 pages of surrebuttal testimony dated October 29, 2018, which was pre-filed with the Commission in docket numbers 2017-207E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed surrebuttal testimony?
No.
If I asked you all the questions contained in your pre-filed surrebuttal testimony here today, would your answers be the same?
They would.
Mr. Chairman, I move that the pre-filed surrebuttal testimony of Jimmy Addison be read into the record as if given orally from the stand.
Mr. Addison's pre-filed surrebuttal testimony in dockets 2017-207E and 2017-305E will be read into the record as if given orally from the stand.
Mr. Addison, have you prepared a summary of your testimony in these proceedings?
I have.
Would you please deliver the summary at this time for the Commission?
Certainly. Good morning, Chairman Randall and members of the Commission. For the last 10 months, I have served as the CEO of SCE&G and SCANA. Prior to that time, I was CFO, and in that capacity, I was responsible for preparing and executing the financial plan for funding the new nuclear project. I was also involved in the negotiations of some of the financial and commercial aspects of the amendment to the EPC agreement in October of 2015, and in managing SC&G's response to the Westinghouse bankruptcy. I come before you today seeking your approval of what I believe is the best path forward for our customers, our company, and the people of South Carolina. Our focus here is on doing what is best to ensure that SC&G's customers have a source of safe and reliable energy to meet their needs in the future. For the reasons that I will discuss in more detail later, I firmly believe that the best option for all affected parties is the one that we have presented through the merger with Dominion Energy. The benefits of that proposal to customers in this state are far beyond anything SCANA could reasonably provide alone. At the end of the day, we are asking this commission to approve one of the benefit plans proposed with the Dominion merger. But before I get to that, I would like to say that this is obviously not where any of us hoped to be when we started this project more than 10 years ago. But two events, Westinghouse's bankruptcy and Santee Cooper's decision not to continue, led SC&G to abandon the project, which we are confident was and is the right decision. On behalf of the company, I want to apologize once again for all of the impacts that this decision to abandon construction is having upon our customers, the ORS, this commission, and the state. We are deeply sorry. SC&G has an obligation to provide its customers with safe and reliable energy, and 10 years ago needed to expand baseload capacity to meet customer demands. In light of environmental policies at the time, it was important to develop a system with reduced carbon emissions and reduce risks of carbon taxes or other carbon emission costs. SCE&G needed to retire older coal plants that could not be retrofitted with modern pollution control equipment. It was important to reduce the company's growing reliance on fossil fuels, including natural gas, which was becoming supply constrained and expensive. The company believed that it had found the best option in the new AP1000 nuclear units. The VC Summer Units 2 and 3 project was one of some 18 nuclear projects on the Nuclear Regulatory Commission's licensing list at that time. SC&G was not alone in thinking that nuclear was the best strategy for the future. Both the Bush and Obama administrations supported the move to nuclear. So SC&G came before this commission in 2008 with a proposal under the BLRA to build those new plants. After nearly 3 weeks of hearings and evidence from 22 expert witnesses, the commission agreed that building those plants was the best option for SC&G's customers. Based on what all of us knew at the time, that was the right decision. The company has always known and disclosed that the plants would cost billions of dollars and would take years to build. The company knew and disclosed that the project had risks and that there were no guarantees that the plants would be completed within the projected schedule or the estimated cost, but tried to provide as much cost certainty as we could for our customers. In the initial EPC contract signed in 2008, more than 50% of the construction costs were fixed or firm. In 2010, the owners negotiated an increase in the fixed or firm portion to nearly 2/3 of the total cost. Then, in the face of continued delays and cost overruns, in late 2015, an amendment was negotiated that allowed the owners to convert essentially all remaining costs to a fixed price. With that amendment, we believed that we had established the cost certainty that would avoid us having to come back before this commission again with another cost increase. Westinghouse, one of the foremost names in the nuclear industry with its global reputation on the line, was now contractually obligated to build these plants by new specified substantial completion dates, backed by nearly $1 billion in potential penalties and lost incentive payments. Westinghouse agreed to bear the risk of whatever increased costs were necessary to meet those dates. Westinghouse's commitment was backed by a guarantee from Toshiba, an investment-grade rated company with a market capitalization of over $12 billion. In 2016, the Commission, the ORS, and interveners present here agreed that the fixed price option was the best path forward, and our decision to trigger that option was approved. On December 27, 2016, however, Toshiba announced that it would reassess the losses associated with the NND project and Westinghouse's other new nuclear project in the United States. In the end, Westinghouse didn't live up to the contractual legal obligations to the Summer or Vogel projects. In March 2017, Westinghouse filed for bankruptcy to back out of its contractual commitments and started us down the path that brings everyone here today. Following Westinghouse's bankruptcy, SC&G evaluated the most commercially reasonable path forward. The owners executed an interim assessment agreement with Westinghouse that gave us access to extensive information concerning future cost of the project, including a new cost assessment recently created by Fluor and Westinghouse's confidential agreements with its subcontractors. All options were on the table, including completing both units, completing only one unit, or abandoning them both. The company inquired of other utilities that were interconnected with our system to see if they would be interested in taking a share of the project, but there was no such interest. The option of continuing the project, however, ended when our partner said it was not going to proceed any further. SC&G could not bear the risk of going forward with the project alone. The only prudent decision was to abandon the plants, which SC&G did on July 31st, 2017. You've heard a lot already in this hearing and probably will hear a lot more, but I don't think anyone will dispute the fact that the prudent decision in July 2017 was to abandon the plants. And although you've heard some argument that SC&G should have abandoned earlier, that ignores the reality of the 2015 EPC amendment and the reasons the company had at the time to continue forward. The numbers clearly established that based on the fixed cost in the amendment, SC&G's customers were going to save hundreds of millions of dollars every year with these plants once completed. It was not prudent to abandon this project prior to Westinghouse's bankruptcy. The only real question that remains for the Commission is what is the best path forward now? Where do we go from here? We've submitted 3 proposals to the Commission: the Customer Benefits Plan with the Dominion merger, the No Merger Benefits Plan, and the base request. You will hear more about the details of the second and third options from Ms. Griffin and Mr. Cocombs, but I want to focus on the first option, which is by far the best resolution. The merger with Dominion will serve to benefit SC&G's customers and the state of South Carolina immediately and for years to come. First, it will put cash in ratepayers' pockets. Under this plan, SC&G's retail electric customers will receive a one-time rate credit totaling $1.3 billion. That will be an average of $1,000 for residential customers of SCE&G. Second, SC&G will effectively give a power plant to its customers. That's the 540 megawatt combined cycle natural gas generation facility that SC&G acquired to replace approximately 45% of the anticipated nuclear generation. Third, Dominion will provide SC&G's customers with a 7% bill reduction. Finally, the merger will accomplish all of these benefits while simultaneously ensuring that the people of South Carolina have a reliable, healthy utility company for the future. SCE&G will remain based in South Carolina, and it will continue to employ thousands in this state. And going forward, it will have the backing of a much larger parent. I should add that Dominion Energy has recently put forward an alternative proposal that amends the customer benefit plan to immediately reduce rates close to the amount currently in place under the temporary rate under Act 258. I will let Dominion Energy's witnesses present that alternative plan. No other proposals in front of the Commission will accomplish what the merger will. There's no doubt in my mind about it. Again, we all regret that we're here today, no one more than our leadership team. Talk of blame is understandable, but it won't resolve the situation. The goal we share is to find the best way to move forward so that over 700,000 customers can be provided the energy service they need and our state can continue to prosper and develop. I respectfully request that when you consider the various proposals, you conclude that the merger with Dominion is the best thing for SCE&G and its customers, as well as the state of South Carolina. The Customer Benefits Plan, or its alternative, is the key to accomplishing that merger. My rebuttal testimony is very short and discusses the reasons why SC&G would not have been able to proceed with the project had the terms of Act 258 been in place in 2008. Thank you.
Mr. Chairman, Mr. Addison is available for questioning from the parties and the commission.
Thank you. Okay, Mr. Guile. Mr. Erskine, if we could get some help with Elmo.
Good morning.
We need to get you behind the microphone when you talk.
Thank you, Mr. Chairman. I will. Mr. Addison, we've had an opportunity to meet each other on a number of occasions over the last 10 years. Bob Guile, appearing before you with Friends of the Earth and Sierra Club. Now, you are more or less the last man standing, Mr. Addison. You were not the CEO when this project began, were you?
That's correct.
What position did you hold at that time, 2008?
CFO.
Chief Financial Officer.
Correct.
Right. Did you have any line responsibilities for managing the project at that time?
No, sir.
Right. Who was the CEO with senior responsibility for managing the project at its initiation, 2008?
Mr. Timmerman.
William Timmerman?
Yes.
Right. And Mr. Timmerman left the company's employ in 2011, is that right?
Yes.
And who succeeded Mr. Timmerman with line responsibility for managing this project at that time?
Mr. Marsh.
Kevin Marsh?
Correct.
Mr. Marsh is no longer with the company, is that right?
That's correct.
And when did he leave the company?
Effective when I took over as CEO, so the end of 2017.
Right. January 1, 2018, you became CEO.
That's correct.
But by that time, the project had been abandoned, and you simply are responsible for managing the abandonment condition of the project. Is that right?
Correct.
How about Stephen Byrne? What was Mr. Byrne's role with the company when he left?
He was Chief Operating Officer of SC&G.
And what responsibility, if any, did Mr. Byrne have for managing the new nuclear development project?
The new nuclear project reported to Mr. Byrne.
He was the senior nuclear officer of the company at the time?
Well, he was a senior executive over all of generation. He had a chief nuclear officer under him, but he was the senior executive, yes.
Right. Now, I want to show you what's been received in evidence as late filed hearing exhibit 46. This is the document that Mr. Burgess was talking about yesterday. That was a SEC filing Form 8K that reflected Mr. Timmerman's continuing consulting relationship with the company. Are you familiar with that document?
Generally, yes, sir.
Is that the copy of the document?
It appears to be.
Now, this was reflected in an agreement with Mr. Timmerman that was generally contemporaneous with the time he left the CEO position. Is that right?
That's right.
Let's turn in that filing to a page that precedes his contract. It's a page 3 of 5 of the SEC filing. Do you see that?
I do.
I don't know whether you can read it from here, but can you read the third paragraph from the top that describes Mr. Timmerman's experience and qualifications?
The second bullet or the
third bullet, Mr.
Third bullet, fourth paragraph. Okay. With Mr. Timmerman entered into?
Yes.
Mr. Timmerman entered into an agreement with our subsidiary, South Carolina Electric and Gas Company, pursuant to which Mr. Timmerman will provide independent consulting services for SC&G with respect to nuclear engineering projects and other generation projects as requested by SC&G's Chief Executive Officer. The term of the consulting agreement will begin on December 1, 2011, and end on the commercial operation date of SC&G's VC Summer Nuclear Station Unit 2 or December 1, 2016, whichever occurs first. Mr. Timmerman will be paid consulting fees of $360,000 per year during the term of the consulting arrangement.
I'm going to turn now in that same filing with the SEC to what's identified therein as Exhibit 10.02, and it's entitled Independent Contractor Agreement. I'm showing page 1 of 8 of that document. Would you read for the record, please, the second whereas in that recital, please?
Whereas contractor during his tenure as Chief Executive Officer of SC&G led the development and implementation of SC&G's plans to construct and operate 2 new Westinghouse A1000 nuclear plants, thereby obtaining detailed knowledge of the regulatory requirements, financing, construction, and other matters concerning a new nuclear project.
Does that accurately encompass your understanding of Mr. Timmerman's qualifications in that regard at the time? Is that accurate?
Certainly I didn't write it, but I don't take exception with it.
Then read the next whereas, please, Mr. Addison.
Whereas SC&G desires to engage contractor post-retirement as an independent contractor and not as an employee of SC&G to provide those services as requested by SC&G's Chief Executive Officer in the CEO's discretion, including but not limited to consulting on nuclear engineering projects and consulting on other generation projects, paren all such services referred to collectively herein as contractor services, close paren.
Right. So Mr. Timmerman was being retained as a consultant in part because of his involvement with the nuclear project and the continuing desire to take advantage of his expertise in that regard.
That's my understanding.
Let's turn further in that agreement. I want to direct your attention finally in this contractor agreement, the agreement that's been referred to earlier as netting Mr. Timmerman the $360,000 a year, and I believe the $1 million figure has been mentioned. Do you know whether that represents the aggregate of payments that Mr. Timmerman received?
I do not know the aggregate. I believe it's set a 5-year term, but I'm not sure of the aggregate.
And do you know whether he was paid over that 5-year term?
I do not.
Right. Let's look at the duties and responsibilities. Now, given that Mr. Timmerman was being retained because of his nuclear expertise and his initial involvement in shepherding this project, can you point to me anywhere in that paragraph that's entitled Duties and Responsibilities that specifies any duties whatsoever with respect to consulting with regard to the new nuclear development project?
I don't see anything there. The only thing I recall is from another earlier paragraph you had me read about at the discretion of the CEO.
So there's whereases about his qualifications, but there's absolutely no duty whatsoever to perform any services whatsoever except services as may be required by the CEO.
Yeah, I don't see anything other than that.
You know, it strikes me, Mr. Addison, that Mr. Timmerman's consulting contract is kind of like the Baseload Review Act contract or agreement that you have. You basically get to do nothing and get paid $360,000 a year. Do you have any documentation whatsoever of what Mr. Timmerman did for this contract?
I don't. It was at the discretion of Mr. Marsh. I don't have anything.
Did Mr. Marsh require any timesheets for Mr. Timmerman?
I don't believe so.
Any written reports?
I'm not aware of any documentation.
So $360,000 for nothing?
I didn't say it was for nothing. I said I'm not aware of any documentation.
You have no evidence of what services were performed, do you?
I don't personally because it wasn't for me.
Well, it was for your company, and you were the CFO at the time. Is that right?
That's correct, but I think it said at the discretion of the CEO. I just don't have anything. I don't know that he did not do something.
So, Mr. Addison, thinking about you and the last year that we've been sort of waiting for these hearings, I must say I was feeling kind of sorry for you. You're the last guy standing, and you're literally the guy that has to come before this commission and defend what happened. And you say you're sorry, but is it fair to say that the company, SCE&G, while sorry, takes absolutely no responsibility for any imprudence associated with the failure of this nuclear project?
I wouldn't agree that we don't take responsibility. I'm not going to get in a dispute with you about prudence, but I will tell you that although I took over January 1st, the plan change was announced October 31st, or around that date. I believe that's correct. And 2 weeks later, we presented a public plan that would have accomplished $1 billion of shareholder commitment, writing off roughly $820 million of construction cost, and throwing in a free power plant that would provide 45% of the energy that would have come out of these two units for SC&G's share. So I believe we stepped forward very quickly. That obviously was not received well. And a couple of weeks later, as documented well in my testimony, I won't waste your time, but Mr. Farrell approached me, and we were here about 5 weeks later publicly presenting that alternative.
So the plan that you first provided or proposed, that was the plan that called for first a 60-year recovery of abandoned project costs at a 2.25% return on equity. Is that right?
I don't remember the exact ROE, but I think that's correct.
And then you backed off and you said, well, we'll only charge you that same ROE, and subject to check, will you accept 10.25% is what you asked for?
Yes.
You backed off and you said 50 years. We'll only charge ratepayers 50 years at 10.25% return on equity. That was your second proposal, correct?
Correct.
Neither well received by the public, this commission, or the General Assembly.
That's an understatement.
Let's turn back to the days of before you abandoned the project. Now, in your testimony, you cite two drivers for your abandonment decision, and neither of those were a decision on your part based on a recognition that the project was no longer economically feasible. You blame first Westinghouse's bankruptcy, and second, your partner Santee Cooper's announced intention to withdraw from the project. Those are the two causes that you cite, correct?
Yes, and if I might clarify, I blame Westinghouse for any of us being here today discussing this. And it's simply that when Santee chose to not go forward, we could not bear it alone.
All right, sir. Now, in your testimony, you say you understood before they actually announced their board vote, and I believe to be clear, your abandonment decision was announced the very afternoon that you learned of Santee's board's action to withdraw from the project, correct?
That's correct.
All right. But your testimony implies that you had some understanding in advance that Santee Cooper management expected to make such a request of its board, and I believe you said based on that understanding, you attempted to shop around interests of other utilities and acquiring an interest in the project. Is that right?
That's correct.
All right. So how far in advance of Santee's board action did you take such an action yourself based on Santee Cooper's information?
Let me be clear. I didn't mean to mislead you there. I didn't do anything personally to explore other companies' interest. I believe Mr. Marsh did. And I believe Santee Cooper did as well, but I can't speak for Santee Cooper, obviously.
Or let's talk about what you can speak to. That's your company. How far in advance of the Santee Cooper board action did South Carolina Electric and Gas, through Mr. Marsh or others, seek to shop around with other utilities an interest in acquiring a portion of the plant?
I don't know the answer to that.
You have no knowledge of any action by SCE&G in advance of the Santee Cooper Board decision to shop some participation in the project with other utilities.
No, I did not mean to answer that. I do not know how far in advance, which I thought was your previous question.
Fair enough. So when did you first learn?
I just don't remember. I don't remember the answer to that. I don't know specifically when that occurred.
All right, let's see if we can tease out any more specifics. You mentioned shopping around other utilities that were connected by transmission to your system. You recall that testimony?
Yes.
What other utilities would that be?
Southern Company, Duke, principally.
Those two alone?
Well, those two were the ones that I'm aware of that were that he discussed it with.
All right. Southern Company had its own issues. They're building the Vogel units. The only other AP1000 is underway, correct?
Right.
I take it Southern Company had its hands full and told you no thanks?
Again, I didn't have the discussion, so I don't know what the interaction was about. I just know the result was no takers.
And Duke likewise rejected any interest in participating in the project.
They did.
But Duke had previously expressed an interest in sharing some of Santee Cooper's ownership interest in the plant, hadn't they?
I believe so, but not directly with me.
Well, whether directly with you or otherwise with your company, you knew that, didn't you?
Generally, yes. I just don't know the details of the interaction because I wasn't involved.
Well, what knowledge do you have of Duke's interest in sharing some of the load of completing this project at a time earlier than the imminent abandonment?
I don't have specific knowledge of it.
How about any knowledge, Mr. Addison?
There was an occasion where Duke did some limited due diligence in our offices to evaluate the project. I don't frankly remember specifically when that occurred.
Mm-hmm. And that came to naught, in short?
It did.
Right. Was SCE&G receptive, cooperative, forthcoming in making any necessary information available to Duke so they can assess the wisdom of participating in the project?
Yes.
Had you heard otherwise?
I'm sorry?
Did Duke communicate otherwise to your knowledge that SCE&G had been unforthcoming, unwilling, and uncooperative in providing financials or other information about the project?
I'm still not sure I understand your question.
Yes, Duke showed an interest in acquiring some fraction of Santee Cooper's 45% share in the project. You knew that, right?
Yes.
Do you know what portion they considered?
I do not.
In order to do due diligence, as you just testified, they approached SCE&G and obviously needed to understand better what the level of risk they were facing in terms of completing the project. And they needed financial information about the status of construction and various other metrics involving the likely completion cost of the project. They needed that, didn't they?
Yes.
Do you know whether or not your company refused to allow Duke access to the necessary information to do that due diligence?
I don't believe that's accurate. No, I believe they got access to whatever they needed.
You think they got access to whatever they needed?
I do.
Then facing that information, the conclusion was they weren't interested.
Correct.
Right. Now, we also know that Santee Cooper, for a period of time, was attempting to shed fractions of its interest in the project. Correct?
Correct.
And ultimately, SCE&G entered into an agreement with Santee to allow them to shed 5% of their 45% back to you, back to SCE&G, correct?
Correct.
But only upon the condition that they saw through the construction phase of the project, paid their fair share of the construction bill, and only upon commercial operation would such a transaction shedding the 5% back to you would that transaction close, correct?
Correct.
Now that agreement with Santee to shed their 5% took place when? Approximately, best of your knowledge.
I don't recall. I'm sorry, sir.
Was it 2015, 2016?
I just don't recall as I sit here. I'm sorry. It's publicly available information. I just don't have it in my head.
All right. Do you know whether it occurred after Duke did its due diligence and determined that it was not in their economic interest to participate?
The due diligence that I'm referred to earlier happened much later, near the abandonment or at the abandonment time frame.
The Duke diligence?
Yes, so the Santee transaction with SC&G was much earlier.
Okay, Santee occurred first. They got this agreement, but only at the completion of the project. So they would have been down to 40% ownership had the project been completed, correct?
That's correct.
And only thereafter did Duke do the review that led to them rejecting participation. That's your testimony?
That's correct.
Okay. Now, how early, to your understanding, did Santee determine that full participation in this project was not in its economic interest?
I don't know the answer to that.
Were you aware that Santee Cooper explored the viability of this project at a far earlier date than toward the end of the project, as you described?
I was aware that they were interested in selling down part of their share. I don't know that I would characterize it as viability.
Well, they made an economic call that paying down their share of the project was in their economic interest, didn't they?
I don't know what was driving their conclusion. I believe it was less load than they had forecasted when they began the project because of the recession and just loss of load.
Just loss of load. We had an occasion to read Mr. Rubin's testimony in this case, the direct testimony of Scott J. Rubin on behalf of the AARP.
I have not.
Has been brought to your attention that as early as 2011, Santee Cooper's consultant, Howard Axelrod, began doing economic viability assessments of the likelihood of selling Santee Cooper's interest to other electric utilities. Are you aware of Mr. Axelrod's work?
No.
Has that ever been brought to your attention?
No.
You haven't read Mr. Axelrod's work, I take it?
I have not.
And can you say that in 2011, no one with Santee Cooper or on their behalf brought to your attention, SCE&G's attention, that they at that time, as early as 2011, were questioning the economic viability of going forward with this project?
I cannot speak to that, Mr. Guild. I was not in the role that I am now at the time, and they would not have had that conversation with me if it occurred.
Well, you were the CFO of the company at the time.
I was.
And were you not informed of the likely cost to complete the project over the course of the project?
I was informed each quarter as the cost information was updated by the contractor.
All right, sir. So wouldn't it have been important for you to attend to economic analysis of the viability of this project as it was going forward in your capacity as CFO?
As I said earlier, my understanding and Santee's interest in selling part of it down wasn't related to the economic viability. It was related to their need for power.
Well, their need for power is in the context of what alternative generation opportunities and choices that were available to them, isn't it?
Well, it could be, or it could have been related to what they projected when they started the project turned out to need a lot less than they thought.
And that's true for you as well, isn't it?
Less than we thought, but as we said when we originally presented the plan, we had flexibility in our plan to retire older coal plants, which we did.
Mm-hmm. Well, for a Santee Cooper, a 45% interest in 2,200 megawatts of new nuclear was not nearly as flexible as, say, bringing on a 300 megawatt combined cycle gas facility, should their load forecast be lower than they expected at the outset of this project. Isn't that true?
I can't speak for Santee Cooper, but I don't take exception with your scenario.
Mm-hmm. Well, are you aware, for example, that Mr. Axelrod in the 2013 timeframe told the Santee Cooper management that he projected that the cost of such a combined cycle gas facility was $500 per megawatt hour as compared to completing the new nuclear plant at $100 per megawatt hour, twice the cost of a combined cycle gas facility?
I'm not familiar with his work.
Are you aware of SCE&G identifying numbers of that magnitude and that time frame for the comparative choice between a smaller gas facility and completion of this new nuclear development project?
Dr. Lynch will have to address that later in our witness lineup.
I'm looking forward to talking to Dr. Lynch, but I'm asking you, the now CEO, are you aware in the 2013 timeframe of assessments known to SCE&G that suggested that the price of the output of this project would be twice that of a combined cycle gas facility?
I'm only aware of what was presented before this commission. Each time there was a cost or schedule update that showed it was beneficial to go forward with the units.
Moment, please. Sure. Now, you heard, Mr. Addison, the discussion before we began with your testimony about the sparring, shall we say, about the availability of the witness, Carlette Walker.
Yes, sir.
Who is Carlette Walker?
She's retired from SC&G. She was previously over the nuclear finance group when she was employed here.
And what was her title?
Vice President of Nuclear Finance Administration, I believe.
And did Ms. Walker, in that capacity, have occasion to provide sworn testimony on more than one occasion, one or more occasions before this commission?
She did.
And what was the general subject of Ms. Walker's testimony in those occasions?
I don't recall the specifics of it, but I believe she would have been presenting information around the projected costs, the escalation schedules, et cetera.
And did Ms. Walker present important information, material to the decisions by this commission about the expected revised capital cost schedules that the company sought approval of in those proceedings?
I believe so.
You had occasion to read the testimony, surrebuttal testimony of Mr. Gary Jones, the ORS prudence witness in this case?
I don't recall. Can't be sure of that.
Let me show you what's in evidence, but it's page 3 of 18 of Mr. Gary Jones's surrebuttal testimony, October 29th, 2018. Do you see the indication in parenthetical bold heading redacted?
Yes.
And then the yellow highlighted lines of testimony that follow from that notation, redacted.
Yes.
I'm going to read from line 6. This is in evidence. Line 5. Referring to Miss Carlette Walker's deposition, which is identified as a surrebuttal exhibit, GCJ-1. Reading, on page 49 of the transcript, lines 7 through 10, Ms. Walker discusses, redacted, I'm quoting, the pressure exerted by Kevin Marsh, Steve Byrne, and Jimmy Addison to get her to lie about the estimated cost to complete VCS 2 and 3 in preparation for her direct testimony associated with the March 12, 2015 filing, parentheses, docket number 2015-103-E, end parentheses. Did you sit here today, were you aware of that testimony by Mr. Jones?
Yes.
Now, do you know what the term perjury means, Mr. Addison?
I do.
Would you accept generally that it's a knowingly false statement about a material fact given under oath?
Yes.
Do you know what the the term subordination of perjury means?
I do not.
That's a fancy word and a word that I think it's only used in a very limited context, but it applies to the concept of encouraging or facilitating another to commit perjury. Would you accept that for purposes of my question as a definition?
I will.
Have you, Mr. Jimmy Addison, or anyone else with SC&G on SC&G's behalf engaged in the subordination of perjury by Ms. Carlette Walker?
I have absolutely not.
That's all the questions I have.
Thank you, Mr. Guile. Other cross. Mr. Knapp. Sorry, didn't see you stand.
You can go ahead. Okay. Although I do take offense to the word short. I am shrinking. I'm getting older. Is this somebody's? I thought it was a parting gift. Good morning, Mr. Addison. I'm Frank Knapp. I would like to start with some of your direct testimony. And if you'd like to get it in front of you just to make sure that I'm reading correctly, I'd appreciate that. You talk on page 16 about the combination with Dominion Energy.
Yes, sir.
At the bottom of that page, you make this statement. SC&G's primary duty is to provide safe, reliable, and efficient service to its customers. It will be able to continue to do so as a subsidiary of Dominion Energy. Without the combination, SC&G's ability to serve its customers effectively over the short term or the long term could be in jeopardy. And the sentence goes on, but I'm going to stop there. To the average person, this kind of sounds like a scare tactic to get the public to support the Dominion offer for the merger. Is that what this is?
No.
So are you saying that unless the merger with Dominion goes through and is approved by the commission, electricity is going to stop flowing?
No, I did not say that.
I know you didn't, but you implied that your services to the customer would be in jeopardy. Is that not an important service?
They could be.
All right. So what services, if that wasn't it, then what services might be in jeopardy?
If we do not have adequate access to the capital markets to provide the services of the company, then customer services could be in peril.
If it's not electricity delivery, what would those customer services be that would be in peril?
I'm sorry, I don't follow your question.
Well, you just made the statement in your direct testimony that you may not be able to provide in the short term or long term the customer services, and you've implied that it's not electricity that will continue to flow. So, what are those customer services that are in peril?
If I must have misunderstood a previous question. I am talking about electric service.
Okay, all right. So that you do feel that it's possible if the merger with Dominion does not go through, there's a possibility that SC&G would not be able to provide electricity to the customer.
I do. We're in a state that is very fortunate to be growing rapidly. We have to invest about $500 million a year of incremental capital into the company in addition to the ongoing operations. So it's a capital-intensive business.
Okay. So there is a possibility then you're saying that electricity will stop flowing to current customers or just future customers?
I'm saying it could be difficult to access the capital that we need to have a healthy company to expand the system, and you can't just separate it from new existing customers and new customers.
All right, thank you. Are you familiar with the South Carolina General Assembly's, that the General Assembly made some pretty significant changes to the Baseload Review Act this year?
I am.
Do you believe that these changes might possibly have an adverse effect on SCANA and SC&G?
They already have.
They already have. I'm going to ask you to turn to page 44 of your direct testimony.
Okay.
And in that, you make the statement that the closing of the combination is also, combination meaning the combination of Dominion and SCANA, is also conditioned on there being no change in the Baseload Review Act or any South Carolina public utility law that would reasonably be expected to have an adverse effect on SCANA or any of its subsidiaries. And you've just testified that it already has had a significant effect on SC, E, and G. So isn't one of the conditions of the combination haven't already been violated?
That is a decision that would have to be made by Dominion,
Okay.
but that's possible.
Okay, so all right, that would be a question then for Dominion.
That's correct.
All right, thank you very much. All right, now you've been very clear that you support the customer benefit plan is the preferred plan of SCANA, SCG, and Dominion, correct?
Correct, and I would just amplify, or the Plan B, if you will.
Sure, and we'll get to Plan B in a second.
Okay.
Two important parts of that customer benefit plan are, the first would be this, as we all know, I've all heard about ad nauseum, the $1,000 average cash back to the residential customer. Are you referring to a cash back? Please refresh my memory. That's not a trick question. I really just want to make sure I call it the right thing.
Well, let me make sure I call it the correct thing, correct as I said it here. A rate credit.
A rate credit. To the average person, that seems like, okay, I'm not sure what they know what that is, but it's been portrayed as they're going to get cash. A couple months after a successful merger of SCANA and Dominion, there will be somehow money being transferred to the customer at a average $1,000 for the average residential customer.
That's correct, and I think Mr. Farrell can address this when he's here, but I think he has said he's open to whatever the commission's desire is. If that's the chosen plan, he's glad to provide that as a rate credit or as a check or however customers want.
That's fair, thank you. It has been described in previous testimony, and you've been here for all the testimony?
Almost all. I had a doc appointment Monday afternoon, and I even tried to listen to the live stream then, but my phone buffered a bit, so it was in and out.
It is difficult to be here for the whole time, although the commissioners do a very good job at that. You're welcome. It has been described in some of the testimony, and I have described it, this rate credit, as a consumer loan because apparently there is no Toshiba money actually sitting in an account of SC&G to be used for this $1.3 billion that's going to go toward making these rate credits available. Is that correct?
There is no money sitting in an account. You're correct.
All right, that's fine. So basically, as has already been described from witnesses, this is going to require SC&G to acquire about $1.1 billion from some place to make this rate credit happen.
That's correct. And again, Dominion can speak to it further, but I think that would be an injection of capital from Dominion.
All right, and then that's what then we later heard. It is actually not going to come from your local bank. It's going to come from Dominion. To your knowledge, is that money free and clear? Is that a gift from Dominion to SC&G to the ratepayer?
Dominion would need to address that.
Okay. All right. Well, that is fine. We can do that. What does the word average mean when we talk about a $1,000 average rate credit for the residential consumer, average residential consumer?
Well, again, they would need to address it, but it's in my testimony. I'll tell you my understanding of it, which is the $1.3 billion divided by the number of residential customers.
Okay. So, but the word average, and most people understand that, although maybe some don't, that means there's going to be a considerable number of residential customers who are not going to get $1,000, and there is going to be some residential customers who do get more than that. Is that correct?
That's correct.
Okay. All right. So not everybody's going to get $1,000.
I agree.
Okay. Thank you. So not all the customers are going to get this $1,000. In fact, there will be some customers who don't get any rate credit. Is that correct?
I don't know the answer to that. I do know that Mr. Farrell said early on in the process, when some of this criticism came up, that he's open to whatever plan this commission and ORS suggest as far as how to distribute the money.
Okay, but you're familiar with the formula that was proposed by Dominion to identify residential customers who should get a rate credit and how much?
I am with the 1.3 billion and the average number, but beyond that, I think you're going to need to address it with them.
Okay, so if I asked you that these are only ratepayers that had an account in 2016 would be eligible for any type of rate credit, you wouldn't be able to testify to that?
I would not.
Okay. So Mr. Farrell will obviously get these questions. Now, but under this customer benefit plan, right now that plan calls for a 7% bill reduction.
Yes.
Okay. Currently, the experimental rate that's in effect right now reflects a 15% reduction from pre-abandonment rates. Is that correct?
Correct.
So if the commission approves the customer benefit plan as currently provided and offered, rates would have to go up from today's rates that people are paying up by about 7 or 8%.
I would agree.
All right, so that would be a nice rate hike. That and SC&G is proposing then that since that's your favorite plan, you're proposing a rate hike from today's current rates.
Let me be clear. That was what was there when I pre-filed this testimony. I referenced the other plan and just said I'll let the Dominion witnesses address that. My impression is that they're open to whatever this commission determines is most beneficial, or frankly, some hybrid thereof.
Okay, thank you very much. Appreciate it. So, but now the Plan B.
Right.
Plan B would also not reduce residential rates by 15%, which were pre-abandonment rates by 15%. Is that correct?
Yeah, my understanding is it would reduce it by 14%.
Okay, so if Plan B in its form as we know it now were to be approved by the commission, that also would be a rate increase from today's rates.
From the temporary rates, yes, sir.
All right. Mr. Addison, thank you very much. I really
You're
appreciate
welcome.
it. Thank you, Commissioners.
Thank you, Mr. Knapp. Mr. Richardson. Okay. Okay. Mr. Cleveland, go ahead. He had just stood up before, so I was just trying to make.
And I asked him, I wanted to make sure that he got to go when he wanted to go. Mr. Addison, my name is Will Cleveland. I'm with the Southern Environmental Law Center representing the Coastal Conservation League and the Southern Alliance for Clean Energy. I just had a few quick questions I wanted to get clarity on in your summary. And when you were talking to Mr. Guild, I believe I heard you say that you blamed Westinghouse.
I do. I don't think we'd be here today were Westinghouse had they honored their contract.
Are you aware that some parties in this case think that blame is a pretty important thing to figure out?
I am.
And are you aware that some of the parties in this case blame SCE&G for where we are today?
I am.
And are you aware that some parties believe that SCE&G acted imprudently in its management of the project?
I'm aware of that.
And are you aware that some parties allege that SCE&G's imprudence means that the commission should disallow cost recovery to a certain extent? Are you aware of that?
I am.
Okay. And am I correct that the company opposes any ruling from the commission that disallows cost recovery?
I would agree with that, with the exception that the plans we put forward eliminate hundreds of millions into the billions of dollars. So, I think it's an academic difference. I don't think it's a practical difference. For example, the Plan B that I was just discussing with Mr. Knapp, my understanding is that takes the construction cost out for anything incurred after March of 2015, wiped out.
This is the summary that was handed out on page 6, line 19. You said, talk of blame is understandable, but it won't resolve the situation. I just want to make sure I understand this. Is it your position that the commission should not weigh all the evidence on prudence and make its own determination of whether SCE&G shares some of the blame?
That is not my position.
Okay, thank you. No further questions.
Thank you.
Good morning, Mr. Addison.
Good morning.
As Mr. Gile pointed out, we haven't seen Mr. Marsh or Mr. Byrne, but we have you here as the face of SC&G, and thank you for being here.
Sure.
You've also been here since the beginning of this project, haven't you?
I have.
And in the 2008 hearing for the original baseload review order, you were asked this question. Once this order is granted and you begin construction, every year you will demonstrate to the Office of Regulatory Staff that you're on schedule, correct? And the answer that you gave was yes. And after the follow-up, you said, in fact, we'll demonstrate to everyone. We'll be very transparent to everyone, rather. What page are you on? Next page, excuse me. So later in that same commission hearing, you were asked this question. Let's get it up there. You see it starts after on page 6. You referred to rate adjustments that are going to be made, revised rate proceedings, filings under the terms of the Baseload Review Act. Would you explain to me, and I guess I might just need to go back and look at some of these things more closely. This is part of the question. It seems that if you have to come back to the commission with revised rate filings, that's only if we've missed the mark because we've anticipated the future correctly. That's the question to you. And your answer is yes, but we'll be filing with ORS, certainly for all to see, completely transparent. And that's important for ORS. It's important for this commission. I'm sure it's important to all the parties intervening, but it's very important to the investment community as well. You remember giving that answer in 2008?
I don't remember it specifically, but I'm sure it's accurate.
And it says that y'all will be completely transparent with the Office of Regulatory Staff, the commission, the intervening parties, customers, and for all to see, right? And as CEO, we've already heard you sign these SEC filings and to make sure that they don't include any untrue statements of material fact, right?
Correct.
And as CEO, you've certified that those filings don't admit any material facts that were necessary in order to make those statements not misleading, right?
Correct.
Right. And you signed those as CFO before as well. And you've signed them actually since 2006, right?
Correct.
And as an accountant, you also know that this omission of material fact can be false and misleading.
I do.
And certainly omitting material facts and information would not be completely transparent. Isn't that right?
Would you give me the question again?
Sure.
I believe I agree, but I want to be sure I understand you.
And I want us to make sure we are understanding each other and that the commission understands us too. You would agree that omitting material facts and information would not be completely transparent either, would it?
I agree.
You think it's appropriate that the Public Service Commission to look at SC&G as the owner of the project for prudence in overseeing construction and the EPC contract, resolving disputes, and in preparing and operating these units?
I think that's fair. I would just say that it was outlined in the application, the responsibilities of the owner.
Okay. And in 2016, you gave testimony to this commission saying exactly that, that you look at the fourth line of your answer, line 14, the commission properly looks to SCE&G as owner for prudence in construction oversight, licenses, administering the EPC contract and enforcing its terms, resolving disputes, constructing facilities, and it continues on the next page. Was SC&G responsible For any person or entity it hired or contracted to construct or supply the project?
We were responsible for the oversight of the EPC contract.
And the EPC contract itself was just a creation of SC&G to carry out its prudence for the project, right?
Yeah, I don't know if I would necessarily agree with that characterization. The EPC contract is, I understand it, is fairly typical on a project of this size, and I think both owners, SC&G and Santee Cooper, desired to have an EPC contract with this consortium to deliver this, because neither of us were experts in nuclear construction.
And SC&G came to this commission and asked for permission and received it to build the nuclear power plant in 2008 and 2009. Isn't that right?
That's right.
And in undertaking the owner's responsibility and prudence in the project, SC&G decided to come up with the EPC contract and to go find somebody to actually help it construct these units, right?
And I don't mean to quibble with you, but both owners decided, and the consortium operated under an EPC agreement. I don't know if they would have operated under some other arrangement or not. I wasn't involved in it.
But before you started working on the project, and when you came to the commission for approval to build the nuclear project, there wasn't an EPC contract that existed, and there wasn't a consortium that existed, was it?
There wasn't an EPC contract for sure. I think the consortium existed before that.
Because SC&G put it together in order to accomplish the project, right?
No, when we may be missing each other here, I don't mean the consortium of SC&G and Santee. I mean the consortium of Westinghouse and at the time Shaw.
I understand. And just so we're clear, because I don't think there's any dispute in this, SC&G decided to do the project and had a junior partner. And from that decision, created all of what has transpired since. Right? You decided to get a consortium to help build it because y'all had never built a nuclear plant before, right?
Correct.
You decided to use an EPC contract with that consortium in order to have them take on some of the responsibility to build the project, right?
We thought that was the best for the customers.
And you could have done it a different way. I mean, there are other options to an EPC contract to building a nuclear plant, right?
I don't know.
I mean,
I'm not a construction expert, so I don't know.
And that's part of the reason y'all developed an EPC contract and got a consortium to help you build it, right?
I think that's fair.
I mean, because even though it wouldn't be practical and wouldn't be very advisable, SC&G could have just created its own construction department like China's national government did and built them themselves, right?
Theoretically, yes. I don't think practically it would have been funded.
I think we all agree. So I was asking earlier that SC&G was responsible for the people and entities that it hired or contracted with to construct or supply the project. Isn't that right?
Well, I think we were responsible for what you put on the screen up there, the oversight of the project. So it's spelled out in the document.
And you're not asking the commission here to believe that SC&G can avoid its responsibility for the project or avoid responsibility to the PSC or ratepayers for construction oversight and management, right?
I'm not.
You're not asking that SC&G avoids responsibility at all because it contracted with someone else to build the units, are you?
I'm not.
And SC&G is not here today trying to hide behind what it did based on advice and counsel from its own lawyers, is it?
No, we're not trying to hide behind lawyers.
There's no question that SC&G was and is ultimately responsible for the project, right?
SC&G is responsible for the responsibilities that were assigned up front when it was approved by this commission. Exactly those responsibilities.
Let's look at the EPC contract. All right. Can I get the Elmo, please, sir? Addison, you remember, familiar with the EPC contract originally dated May 23rd, 2008?
Yes, generally.
I'm going to put up 3.5 of that agreement, execution version. All the way out. Says, and you see the first highlighted line in the control of work in section 3.5 of the EPC, where it says the owner as licensee shall be ultimately responsible for the execution of all obligations and responsibilities under the COL. Did I read that right?
I believe you did.
And do you understand that to be true?
I do, as well as the next line.
Right.
That
And-
the owner has delegated to the contractor the overall control and implementation of all aspects of the work.
And in the COL is the fundamental combined operating license for which there could be no construction or operation of the nuclear plant, right?
The CO there could not be construction of nuclear island related efforts or operation of the plant without the COL. There, just to be clear, there was extensive what I would view as construction occurred before a COL was received and was allowed.
And so it's true to say that without the COL, there's no project, no nuclear power plant project.
I would agree.
And so would you agree with me now, despite the fact that the SC&G chose a different process, an EPC contract, and had to get an experienced or a contractor involved, that the owner is ultimately responsible for all obligations and responsibilities for this project?
I can't agree with that. I'd agree that the owner's responsible. SC&G, I can't speak for Santee. SC&G was responsible for the responsibilities delineated in the application as approved by the Commission in 2008.
Look at, you keep mentioning Santee Cooper, and let's just look at the owner's responsibilities under 3.6A, the very first section of that. And Santee Cooper actually appointed SC&G as its limited agent for this construction project, didn't it?
I'm not familiar with the detailed arrangement between Santee and SC&G, I'm sorry, but generally Santee was a junior partner, as you said earlier. I would agree with that.
And the highlighted section shows that SC&G is telling the contractor that they shall have the right to rely on any representation by SC&G that it has the authority to act on Santee Cooper with respect to all matters pertaining to this agreement, right?
That's what that says. I believe there were other provisions, and I can't refer you to them now, that had fairly low monetary levels that required Santee's concurrence for matters related to the contract. I didn't administer the contract, so I just can't refer you to those.
The contract is how SC&G was using its ultimate responsibility to try and get the project built, right?
Yes, the contract bound the owners and the consortium to the terms of the contract.
And specific to SC&G's decision to use an EPC contract to hire a consortium to design and construct the project, did SC&G had clear rights of access to inspect contractors and subcontractor facilities and audit quality assurance and manufacturing techniques? Are you familiar with that?
Yes, sir. I can't speak to that directly. I'm generally aware of it from hearing third hand, but I don't have a direct experience in it. It just wasn't my responsibility to oversee the project.
Since you're here on behalf of the company, let's just look at what the agreement shows. I've highlighted two lines there. One is that the contractor shall provide the owner and its authorized representative reasonable access to work at contractors' facilities and all pertinent documentation relating to the work. That was the access at the contractor facilities. 5.4. And then 5.5, you see where it's access and audits at the subcontractors' facilities. You see that?
I do.
And are you surprised to learn that the SC&G had this right of access and auditing at the facilities of both the contractor and subcontractors?
No, I'm not surprised at all. As I said earlier, I've heard that described before by Mr. Byrne, for example, where we had inspection at various facilities. I just can't attest to it personally. I wasn't involved in it.
Okay. Are you familiar with witness and hold points?
Similar answer. I'm familiar with Mr. Byrne describing it. I'm not personally familiar.
And just so that we understand what we're talking about, I'll put the definition from the EPC of hold point. Hold point was a critical step in the manufacturing or testing process beyond which the contractor or subcontractor cannot proceed except to, and 5.6, you see that?
I do.
We see how critical, I mean, we hear how critical the hold points are, and here we're talking about specific vendors for equipment. And the second highlighted part is that after a review, an owner may identify additional witness points or hold points. And then the next is the contractor shall provide an owner access and copies to these manufacturing and fabrication schedules and regular updates. And then in B, it brings it together for why this is important. Work may not proceed with or beyond owner-designated hold points without a written waiver from the owner. Do you see that?
I do.
And does that make it pretty clear the level of right to control that the owner has, even once it's delegated to the contractor in this EPC contract?
It does, and I think Mr. Young can speak extensively to that.
Thank you. And I think I'll just put one more up because I agree. It's something that that SC&G contracted with the consortium, but we want to make sure that there's also this specific owner's right to inspect and stop work. I mean, they can go into not just the contractor, subcontractor, but equipment manufacturers and actually issue stop work. And it doesn't surprise you that there's that level of control on something as important as nuclear power plant construction project, is it?
It does not.
Thank you very much. I think you've answered this. Mr. Byrne, right, and his staff at SC&G was primarily responsible for exercising the project management and oversight, including these contractual rights, wasn't he?
That's correct.
And there's no doubt that SC&G had an obligation to report updated construction schedules to ORS and nuclear construction quarterly reports, right?
I agree.
And that SC&G was also required to file its nuclear construction quarterly reports with the commission.
Right.
You remember that? All right, let's talk about compensation. Something we have to get out into the record here, and it's publicly reported, right? It's in the 2017 proxy statement.
Yes, and we had two proxies, correct? So in 2018 we had two because of the merger.
That is not merger related, I don't think. Can you tell if this is the chart it's actually included in multiple SEC filings? This is the one that shows the 2014, 2015, 2016 compensation for senior executives of SC&G.
Okay.
All right. And in 2014, it's over here on the far right column. You can see, if I can zoom in, I will. On the left side, it identifies the particular executives and starts with salary, includes bonuses and awards, and then on the far right, it's got the totals. And Mr. Marsh is at the top. It shows his salaries, total compensation in 2016 is over $6 million and over $5 million for 15 and 14. And below that is your total compensation for 16, 15, and 14, all of which are right at or over $2.5 million. Mr. Byrne is below you, same level of salaries. And are those total compensation numbers correct?
They are certainly correct for the SEC filing. Those are not necessarily the compensation that the individuals receive, but they're specific rules what the SEC has about what you have to file. So some of those are projected that could be earned in the future.
And those types of aspects of the compensation could include stock options and other projected, not just projected, but bonus type compensation.
I would agree with the latter. SCANA does not pay with stock options.
Could it include unvested equity awards?
Yes.
Okay. And to the general public, I know to an accountant, obviously, and the SEC is very different, but to the general public, they would understand an unvested equity award as a future stock award.
Yeah, I won't quibble with you over that.
It's an unvested equity award means you're going to get stock later.
It means you might, depending upon if you earned it or not.
And you received bonuses tied to this project, didn't you?
I didn't receive any bonuses tied to the construction of the project. I received some of my goals were related to obtaining the financing for the project.
All right, you received every bonus award for which you were eligible that was tied to this project, didn't you?
I don't know of exceptions to that, so I would agree with that subject to check.
And
My goals were related to raising the capital, and we raised the capital, so I expect I met them.
And part of this compensation for you and the other senior executives at SCANA that y'all received was included in the company's revised rate filings with this commission, wasn't it?
None of mine was.
None of yours was allocated to this project in any way?
That's correct.
How about Mr. Byrne?
I believe Mr. Byrne was because he was directly working on the project.
And Mr. Marsh, too?
I do not believe Mr. Marsh's was.
There were other senior management that were working on the project that had their salaries and bonuses allocated to project costs.
Yes, sir, we have to. That's appropriate accounting.
And those that compensation and bonuses that were allocated to the project and part of the revised rate filings were charged to customers, weren't they?
Yeah. Again, not to quibble with you, but as some of the witnesses made clear yesterday, the actual cost weren't. The carrying cost on it was. So none of the cost of the project has been charged to a customer yet.
Right. And thank you for being more precise. So basically, the ratepayers had to pay the financing costs of part of the salary and bonuses for senior executives from the project, right?
For those that work directly on the project.
And they also, the ratepayers had to pay basically a 10% return on equity, which was on those financing costs for that salary and bonuses too, didn't it?
They did for the part that was financed with equity.
The new nuclear finance team, had a bonus goal back in 2014. I think you might remember to file the required modification proceeding in the PSC. You know what I'm talking about?
I do, only because Mr. Cox asked me about it in a deposition a few weeks ago.
So your recollection was refreshed that the new nuclear finance team had a goal that in 2014 they would file a modification for the schedule and budget.
Correct.
And that would be tied to a bonus if they were able to accomplish that goal.
Correct.
And And you permitted that finance team to actually receive that bonus, even though the filing wasn't made until March 12th, 2015, right?
Well, if I remember correctly, from that exchange he and I had, I think what occurred is I allowed them to substitute a different goal for that goal because the information was not available from the consortium in time to make that filing.
So you recognized essentially that that wasn't achievable. Let's look at the email if you can bring it up. This is an October 28th 14 email, and we're going to look at the if you want, the very bottom of the first page. Thank you. This you can say, I say we would need, this is actually coming from you to Ms. Walker, right? I would say we need to respond that we have met the portion of the goal that was achievable, and the remainder will be accomplished in 2015 and allow for completion. Does that make sense? And then you go up, and you'll see response is yes from Mr. Addison, just a little higher. He says, yep, okay. So that's the agreement. Go to the top of this page 2, which is where we talked about it was done because it wasn't achievable. One bonus goal that is unachievable is the second goal, and quit moving. It was at the top. See, the second full sentence, the one bonus goal is unachievable. It was our second goal, and that was the goal to file a modification within 2014 for the budget and schedule, right?
Correct. And this was a goal for the team, the accountants, and clerical support staff that worked for Ms. Walker. And I didn't, this was very rarely done, but I didn't feel like it was fair to punish those employees for something that was outside of their control.
And we're going to talk about this team in a little bit, maybe after lunch, but this is the EAC review team, right?
No, this is her New Nuclear Finance Administration.
This is the whole New Nuclear Finance team.
Well, you say the whole team. Yeah, I guess it was 10 employees or so.
That Ms. Walker was in charge of?
Correct.
All right. Let's turn to this irrevocable trust. You know, SC&G created a $110 million irrevocable trust to store and protect that cash, pay senior executives and managements who lose their job through the merger. Is that right?
Not entirely. So the trust is a fairly common structure in the corporate arena when mergers and acquisitions are involved. It had been established, as far as I remember, a couple of decades ago. I think most companies have it. And it was implemented at the time of the merger, as it was set up to do. Less than half of the funds in there are associated with senior management. The majority are associated with the over 200 leaders across the company. And less than a third of the total amount is associated with any change of control.
All of it is for the top 200 people at SCANA, right?
It's more than 200. I don't remember the exact number, but yes.
And in January 2018, this year, in the middle of, right as you pointed out, right after the merger was announced, but in the middle of dealing with the abandonment itself and the financial challenges resulting from that, SC&G took $110 million of cash from its operating accounts and put it into this trust, right?
I believe that happened at the SCANA level, but I'm not positive about that.
If it didn't happen at the SCANA level, it happened at SC&G's level, right?
Actually, I believe it happened at the SCANA level and would proportionally be associated with each of the subsidiaries on a relative basis.
And we've heard SC&G's wholly owned subsidiary of SCANA, right?
Correct.
So this was $110 million of cash, and all that cash is still in that trust today, isn't it?
I don't believe all of it is. I think there's been a reduction of the amount, but Ms. Griffin could give you specific details.
But when that cash is in the trust, right, it can't be used for anything else. It can't be used for services or capital improvements or make debt payments, can it?
That's correct.
And in fact, that's the purpose of the trust, right? So it can't be used for anything else.
That's correct.
And out of that trust, Mr. Addison, you're personally going to get about $10 million if the merger closes, isn't that right?
Oh, if I could expound upon that, the only reason anybody gets change of control is if the merger, our plan has a two-step process. If the merger closes and if you lose your job. So only in that case would that be effective. And I believe it's slightly less than $10 million, and about half of that amount in my case, as we were discussing earlier, equity awards, was from prior equity awards from previous years that would be paid if I lost my job and wouldn't be there to receive the payment at the time that they would have earned out. So the remaining half is roughly about 3 times my pay and annual incentive is really the net of what would be there if the merger closes and if I lose my job.
Thank you for that explanation. I also raises the question about if you were no longer there, that Mr. Marsh and Mr. Byrne are going to receive more than $1 million too out of that trust if the merger occurs in it, won't they?
I don't know the specific amounts. The only thing they would receive is any remaining term on prior equity awards that they are contractually due. They would not get anything from change of control.
And in fact, they're going to receive merger-related compensation, aren't they? You can look on the board. Mr. Marsh there at the top line is going to receive in unvested equity awards that will automatically vest at the effective time of the merger and paid out in cash pursuant to the merger agreement over $3 million. Isn't that right?
Could you show me footnote 2? I believe this is what I was just referring to, that these are prior equity awards that they're contractually due that were awarded in previous years before they retired.
Which could also be labeled, we talked about already, unvested equity awards?
That's correct. So typically not typically. In our case, these are a 3-year term, so they're called long-term to make sure you're not just focused on the short-term results. And at the time of their retirement, there are multiple classes of those 3-year awards that are still left, and this is the tail periods of those that are out there. This is nothing extra associated with the merger.
But it is associated with the merger as merger-related compensation because those unvested equity awards for Mr. Marsh and Mr. Byrne vest automatically, right, at the time of the merger?
They would, and if the merger were not to occur, they would vest at the normal time on the calendar when they would mature.
And would you zoom back into the payment so we can see what Mr. Byrne is going to get in merger-related compensation? He's the third line down. If you go all the way to the right, over $1 million, and you can see there the rest of the senior executives and their merger-related compensation. Are those the right numbers as far as you know?
Yes.
So these are the cash payments that will be received after the merger out of that $110 million irrevocable trust, right? If the merger occurs.
That's the gross compensation. Obviously, there are taxes associated with with this. There's an extra 20% excise tax associated with it. So again, I don't know what the cash is for the specific individuals.
And they might have their own individual tax circumstances that would affect that too. But this is the gross merger-related compensation is going to be paid in cash to these senior executives out of the 110 irrevocable trust, right?
I think we commingled two things here.
All
So
right.
you've asked me about Mr. Marsh and Mr. Vernon. Let me be clear. These were prior awards that were made before they retired from the company. If the merger occurs, they will get this compensation. For the others, myself, Mr. Kassam, Mr. Archie, Ms. Griffin, those will only occur if the merger occurs and if we lose our jobs.
And all of these amounts are secured by the cash that's in the irrevocable trust, right?
Correct.
Let's talk about Carlette Walker. We've heard she was the vice president of SCANA, right?
Correct.
She was the corporate officer in business and finance.
Of Nuclear Finance Administration. I think business and finance is another department.
And she was promoted through the ranks of the company for 2 decades, right?
Yes.
And not every accountant in the company gets to be a corporate officer, do they?
That's correct.
And only those accountants that the company believes are trustworthy and honest and diligent.
I would agree with that.
And Ms. Walker reported directly to you, isn't that right?
She did at the end of her career.
Okay. She was assigned that, as we've talked about, the responsibility by SCANA to oversee the finance on the project.
Yes.
And she was the head. Excuse me. She's actually the head of business and finance for the project, right?
Again, she was not head of business and finance. Someone else was. She was head of Nuclear Finance Administration.
Nuclear Finance Administration for the project. And that's a pretty big assignment the company gave for a Bet the Company project, right?
It's a big assignment. I would agree with that.
In fact, this was the biggest financial undertaking the company had taken in decades, wasn't it?
Yes.
And Carlette Walker had approached you on more than one occasion in 2015 with concerns about the company's disclosures about the project, didn't she?
No, I wouldn't characterize it that way. Carlette approached me about her concern about the performance factors, the performance of the contractor, being able to meet their budgeted performance factors.
And how those concerns intersected with disclosures being made about the project. Isn't that right?
She did not approach me multiple times about disclosures related to performance.
But you would expect and want a corporate officer who had those concerns to approach a senior member of the team, wouldn't you?
I absolutely would.
And she was correct to do that, wasn't she?
I just said she didn't do it multiple times, but yes, she would be correct if she did it.
Were you aware that she expressed concern to another SC&G employee that she might go to prison over her role in the company's disclosures?
I read the email in the deposition.
And who is Miss Evelyn Varn?
She's an employee in our telecommunications department.
In the top there, she goes on after saying, I don't want to go to prison over this job. She continues and says, I wouldn't get any backing if it came down to someone making me one of the fall guys. You see that?
I do.
Do you think that's happened?
No.
You don't think Ms. Walker's been made one of the...
I do not.
You knew that in 2015 that her husband was sick and that she was spending a lot of time with him in the hospital?
Yes, she told me that.
Yeah. I'm going to go into another area. Mr. Chairman, happy to go ahead and keep going or...
If you're getting ready to switch gears, we're going to switch out of here until 1:15.
Thank you very much.